this. What are your priorities?
I have lots of priorities.
Okay.
And I do have some things that are very important to me. I think that, one, it's fundamental. Single most important thing that is my priority is that I work every day. And I think we all need to work every single day to make sure that people have trust and confidence in our courts. Our courts serve by consent of the people. When people come to court and they get a decision that they don't like, in our country, something very remarkable occurs, and that is that people voluntarily accept the outcome and they move on with their lives. Sometimes they may take that decision and take it to the Court of Appeals, but at the end of the day, they voluntarily accept the outcome and move on with their lives, and I think that's remarkable. People will do that only when they have trust and confidence that they've had a fair trial, a fair hearing, that they've been treated well by the courts, that they know that they've been heard, that they know that they've been heard by a fair and impartial judge. And we need to work at that and maintaining and building on the trust and confidence of people every single day. I do that in part by setting a good example across the state, by talking with judges and those that work at courts, and I do that a great deal, to make sure they understand they need to treat all people with respect and courtesy. They need to make sure that all people are heard. They need to make sure that that they are in fact impartial, but that people understand that. I also think that we need to do a much better job with diversity in our courts, for several reasons. One of which relates to the trust and confidence that I just spoke about. The reality is that if somebody comes into court and doesn't see anyone they can identify with, not the judge, not the clerk, not the bailiff, they see nobody they can identify with, that can be a scary experience. That can be frightening. They begin to question and wonder whether this is going to be a good experience for them, or that they're going to be treated fairly. If they do see somebody that they can identify with, there's a much better chance that they will understand that maybe the experience is going to be okay. And that's very, very important. Another reason I think it's important for us to work on diversity is that we're missing out on a great deal of talent in minority communities across the state in our hiring pool. And we need to expand our hiring pool to include more minorities, and we need to do that by actively reaching out to those communities, letting them know that we welcome their applications, that we welcome them coming to work for not only the Supreme Court, but courts throughout Ohio. And we've not done a very good job of that. And we need to do more. I'm interested in working on matters involving technology. My predecessor, Tom Moyer, who I've learned a great deal from and have great respect for, was a proponent of technology. And he did a nice job of helping the court create a website where decisions are available, where briefs are available. But the way we operate is oftentimes by scanning those documents. And we have staff spending literally hundreds of hours taking apart documents and scanning them so that we can post them online. These same documents were produced in law offices across the state electronically, but the current system requires them to make 13 copies and haul those down to the court for filing, where we take them apart and scan them. Federal District Court in the Northern District of Ohio, where I grew up and began practicing law, was doing e-filing more than 25 years ago when I was e-filing in that court. This is not new technology. One of the last things I did as a probate court judge before leaving Franklin County to serve as Chief Justice was to sign a contract with a vendor for e-filing in the courts in Franklin County. I've already begun talking with my staff at the Supreme Court about moving toward e-filing in the Supreme Court as soon as we can. And beyond that, another very important matter that I'm working on is the budget. When Governor Strickland and I spoke about the appointment, spoke about the need for leadership in the court immediately, and spoke about the challenge of following Tom Moyer, the challenge of following him particularly under these difficult circumstances. I was up to that challenge, and I believe that I've done a very good job of providing continuity, providing smooth transition, and of providing compassion to the staff and to others who were mourning the loss of Tom Moyer. But the governor and I also spoke about the importance of my need to develop a budget this year, the need for a leader to be in place, and that's what I'm doing, is developing a budget that will respect the administration's budget request and understand the state's budget situation. I also recognize that many local governments are not likely to fare well with the state's budget, and I need to take those things into account as I develop a budget for the judicial branch of our government, as well as for the Supreme Court. I also understand the constitutional imperative that we keep the courthouse doors open, that we resolve disputes fairly and quickly, and that courts continue to provide justice. I'm in the process of developing that budget. We have a draft that we'll be submitting on November 1st that addresses those needs. In fact, just today, just this morning, I shared a summary of our draft budget with my colleagues at the court so that they could provide me with their ideas and their input. This is a step that has never been taken before, but I do welcome the input and ideas of my colleagues, and we'll see if they've never before participated in the budget process, but I'm hopeful to get something good from that.
I was just talking to I talked to Justice O'Connor this morning, and she said that, and I don't want to get into he said, she said stuff, but she said that the late Chief Justice did seek input from the other justices in developing the budget during the process. And she was critical that she hadn't seen anything from you yet. Do you think you've handled it? It sounds like you think you've handled it the right way on the budget, on the draft, and what you've done.
Not only have I handled it the right way, I've handled it the way that Chief Justice Moyer handled it for all of his years in service. I've worked on this extensively with our Administrative Director, Steve Holland, with our Finance Director, Rhonda Perry, in developing a budget. And I've done something beyond what Chief Justice Moyer ever did, and that is that I am reaching out to the other justices for their ideas and for their input, a step that my predecessor never took.
How difficult is this draft budget? Are you looking at, I mean, I've heard the number 10% cuts in your discretionary. Is that what you're looking at?
Yeah, what I was asked to do by the Office of Budget Management, my OBM, was to prepare two budgets. One that is flat funding from fiscal year 2011, the other one that reflects a 10% reduction in discretionary spending for fiscal years 2012 and 2013. That's what I'm doing, and it is challenging to do that. It requires us to make hard choices. It requires me to make hard choices. But I understand the importance of doing so. I know that we need to be good stewards of public resources. We need to be fiscally responsible. And that's something that I've had tremendous experience doing in the past. and that I will do with the development of this particular budget for the court.
Not delving into the details or asking for any opinions on any pending litigation, but what role should political parties play in the Supreme Court or judicial races in general? Do party labels matter?
Well, what's interesting is that the question is one that I think is appropriate to ask of voters. I think for some voters, those labels do matter. For some voters, they want to know what parties are supporting their judicial candidates. And I think that we shouldn't be the ones telling voters, no, you're not entitled to that information. Or no, that information isn't something that is appropriate for you to consider. I think that I trust voters. And I think voters are entitled to all of the information that they think is important to them. If there are voters who don't care about that, they'll set it aside. If there are voters that do care about that information, then they should have ready access to that information. I'm not going to suggest to voters what should and should not be important, or on what basis they should make their personal decision to cast their vote.
Your opponent has thrown out a proposal to make primaries nonpartisan. What do you think of that?
I don't think it's very workable. I don't think it's been thought through. I think that it creates a lot more problems than are needed. And I think it gets in the way of, as I said, the public having information that they may consider to be relevant or important.
What kind of problems? I mean, what would that cause?
Well, for example, at this point, we have primary elections that are partisan, where each party has a contest to choose their nominee, and we have a provision that allows independent candidates also to get themselves before voters. That's a system that has existed for decades, if not centuries. It's a process that seems to work pretty well.
Okay. Is the current court imbalanced?
I think the current court can benefit from the breadth and depth of my experience. I bring a different perspective, a different approach, different experience, different ideas. And I think it's very, very important to have a mix of people and a mix of backgrounds and ideas on that court. That's why we have 7 seats for 7 justices, to make sure that we have a good mix of people in every dimension. We should have a mix of people philosophically, geographically, racially, ethnically, by lots of different dimensions. And the court's not been that.